of Midlands versus Dakota Sutcliffe. My name is Judge Tilewick. Can the attorneys make their appearances, please?
Good morning, Your Honor.
Good morning.
My name is Cara Adams. I, along with my co-counsel, Emma Roeder.
Good morning, Your Honor.
Good morning.
And Brooke Conklin.
Good morning, Your Honor.
Good morning.
We represent the prosecution in today's case.
Okay, defense counsel.
Good morning, Your Honor. My name is Madeline Stanton, and today I will be representing the defendant, Dakota Sutcliffe, along with my co-counsels, Nikita Vandrangi.
Good morning, Your Honor.
Ooh, lots of feedback. Okay.
And Vince Popello.
Good morning, Your Honor.
More feedback. Okay. Any preliminary matters, plaintiffs, state's counsel?
Yes, Your Honor.
Sure, go ahead.
To start, the state moves to invoke Rules 603 and 615 to constructively swear in and sequester all witnesses, barring party representatives.
Sure.
At this time, Your Honor, the state has also compiled a trial binder for your use today throughout the trial. May I share this with you via the chat?
Yes.
At this time, Your Honor, the state would like to draw this court's attention to stipulation 12. Now, this stipulates that if Dr. Weber is not called by either side today, then it is mutually agreed upon that the fire at Chuggy's Bar was in fact man-made and that fire was accelerated using paint thinner.
Okay.
In addition to that, Your Honor, the state would also like to draw the court's attention to stipulation 14. Stipulation 14 says that at any point in today's trial, either side may read onto the record trial transcripts from Dakota Sutcliffe's previous trial.
Okay.
At this time, I would just like to inquire for your preferences for screen sharing. Should we always ask permission prior to screen sharing, Your Honor?
No, that's unnecessary.
With that, Your Honor, the prosecution is ready to proceed.
Okay, you can proceed now. Is it at my end or I don't hear any sound?
Your Honor, can you see and hear me okay?
But now I can. Yeah, now I can.
Wonderful.
Terrific. Yeah. You may proceed.
Yes, Your Honor. Opposing counsel, members of the jury, may it please the court. She was running out of time. There are quite a few things that both the prosecution and the defense agree about the night of July 31st. The defense does not dispute that someone was inside of Chuggy's on July 31st, that someone poured paint thinner all over the bar, that someone lit a match, and that they walked out. The defense acknowledges that Chuggy's Bar was engulfed in flames, that smoke billowed up inside the windowless building, bursting at the seams. But most importantly, the defense admits that someone lost their life in the fire at Chuggy's. You'll hear that a firefighter by the name of J. Lynn Williams went inside the building in search of survivors. And you'll hear that on his rescue mission, the ceiling of Chuggy's collapsed. Mr. Williams' skull was crushed and Mr. Williams died instantly. We as the prosecution know who was responsible for the death of Mr. Williams. You'll hear it was none other than the owner of Chuggy's himself, Mr. Dakota Sutcliffe. And today you will hear why he did it. You'll hear from a forensic investigator who will tell you that the defendant owed $1 million and that he was running out of time to pay that loan. You'll hear that Midlands was hit hard by the pandemic, that business at Chuggy's was closed, but the bills kept piling up. You'll hear that Midland State Bank offered extension after extension to the defendant until finally the bank had to say, enough. The defendant knew he could not come up with the money in time. He knew he was going to lose his investment and be left with nothing. Unless the defendant could collect on the $1.5 million insurance policy that he had for Chuggies. Then the defendant could walk away debt-free and with $500,000 in his pocket. You'll hear today that the defendant set his own bar on fire because he had nothing to lose and everything to gain. And in setting his bar on fire, he thought he was walking away with $1.5 million. We as the prosecution know that this is what happened on the night of July 31st, and it is our job today to prove this to you. We will prove beyond a reasonable doubt that the defendant committed aggravated arson and had a intent to defraud. To do this, we will prove to you three things today. First, that the defendant committed arson when he set Chuggies on fire. Second, that by setting Chuggies on fire, the defendant was creating a substantial risk of serious harm to another person. And third, that the defendant knew of this risk when he set the fire. I'd like to talk to you about those three elements today. First, the act of arson. You'll hear from an employee of Chuggies today who will tell you that on the day of the fire, Chuggies received a shipment containing gallons and gallons of paint thinner. You'll hear from an eyewitness by the name of Skylar DeYoung, who will tell you that just minutes before the fire at Chuggies, she saw the defendant sneak out the back door of Chuggies. And when she saw the defendant, she'll tell you he reeked of paint thinner. Second, the harm. You'll hear from an account of a detective who was at the scene of the fire at Chuggies. You'll hear that Mr. Williams' body had to be dug out from underneath the rubble, and that when his body was pulled out, it was covered in severe burns. You'll hear that Mr. Williams died before any help could have ever reached him. And third, the knowledge. You'll hear from one of the defendant's own employees that the defendant was an active firefighter in the Midlands community. And as a firefighter, the defendant knew of the knowledge of the danger and risk that fires possess. Members of the jury, the defendant is out of time today, but you have time to bring justice for the life of Mr. Williams. That's why at the end of today's trial, my co-counsel Emma Roeder will come before you. She will lay out the evidence and the law in today's case, and she will ask you to find the defendant guilty of aggravated arson because the defendant is out of time. Thank you.
Thank you. Defense counsel?
Yes, Your Honor. May I proceed?
Yes.
Your Honor, opposing counsel, members of the jury, may it please the court. You see what you want to see. On the night of July 31st, a tragic fire occurred at Chuggies, a bar that was owned and run by Mr. Dakota Sutcliffe. And now, Mr. Sutcliffe is being wrongfully accused of setting fire to this bar. Mr. Sutcliffe purchased Chuggies when it was just an ordinary run-of-the-mill bar. But Mr. Sutcliffe had a dream, and more importantly, he had a vision, and he got right to work. Mr. Sutcliffe ran a tight ship at Chuggies, not wanting to cut corners and break rules, and soon Chuggies was a classy and tasteful establishment. Mr. Sutcliffe even began renovating the bar. He wanted this bar to reach its full potential. Unfortunately, the COVID-19 pandemic put an end to all of that. But Mr. Sutcliffe wasn't discouraged. He came up with creative ways to keep his bar afloat and running, and business was looking up. But then, on the night of July 31st, a devastating fire destroyed Chuggy's, a bar that Mr. Sutcliffe had put his time, money, and hard work into, only to watch it all come crashing down right before his very eyes. The burden of proof in this case today lies with the prosecution. They must prove beyond a reasonable doubt that Mr. Sutcliffe did in fact commit this crime. If there is even the slightest bit of doubt in the evidence you will hear today, the prosecution has not met their burden. In fact, we are confident that they will not meet their burden because the prosecution will ask you to see what they want you to see. But the defense will simply ask you to see the truth. We will do so by calling 3 witnesses to the stand today. First, we will call Dr. Mel Jelani. Dr. Jelani is a forensic psychologist, and his testimony will explain just how the prosecution will get you to see what they want you to see. His expertise in the areas of visual and memory processing will explain how the circumstances on the night of the fire actually create significant obstacles to an accurate and reliable perception of that night. Next, we will call Miss Maddox Vaughn to the stand. Miss Vaughn is a loyal customer of Chuggy's, and her testimony will ask you to see the truth about a passionate owner who worked hard to renovate his business and keep it afloat and running during a difficult pandemic. And finally, we will call Miss Alex Silva to the stand. Miss Silva was a responding firefighter on the night of the fire, and again, her testimony will ask you to see the truth about that night. She will explain the strategy the fire personnel used in putting out the fire, as well as the unfortunate events that led to the saddening death of her partner, Jalen Williams. The prosecution must prove 3 things today. First, they must prove that Mr. Sutcliffe did in fact commit an act of arson. 2, that he did so with the intent to defraud. And 3, that in doing so, he created substantial risk of serious physical harm to any person other than himself. Members of the jury, after hearing the evidence today, you must ask yourself, did the prosecution prove this charge and meet their burden, or did they simply ask you to see what they wanted you to see? The fire on the night of July 31st was a tragic accident and nothing more. And because of this, at the conclusion of this trial, my co-counsel, Madeline Stanton, will ask for a verdict of not guilty. Thank you, Your Honor.
Thanks. Before the prosecution calls its first witness, please switch to gallery view. This will allow you to see the attorneys and the witness at the same time. Also, I should note that when the defense appeared, there's a fairly pronounced amount of feedback. So perhaps one of you who had your mic on during the opening statement of the defense counsel might want to check if there's a problem. Anyway, prosecution, why don't you call your first witness?
Yes, Your Honor. The prosecution calls Ms. Skylar DeYoung to the stand. Please state your name for the court.
Hi, everybody. My name is Skylar DeYoung.
How are you involved in today's case?
I used to be a bartender at Chuggy's, the bar that got burned down.
Can you tell me about your experience working at Chuggy's?
When I first started working at Chuggy's, it was like the epitome of a college bar. I'm talking lights so old, they were basically Dollar Tree strobe lights, floorboards so sticky that every single time you took a step, it almost ripped your shoe off. And the walls were covered in the most random assortment of junk you've ever seen in your life. It was gorgeous. But all that changed when Dakota took over as the owner.
What changed when the defendant became the owner of Chuggies?
Dakota essentially gutted the place. When I say that he renovated everything, I mean everything. It was practically an entirely new building by the end of it all.
I'd like to talk about these renovations. What changed inside of Chuggies?
Well, he started by ripping up all of the old floor and replacing it with solid French oak hardwood floors. And then his next victim was the bar counter. What once was some regular old granite became elegant marble. And then he added new mink fur bar stool covers. And as if all that wasn't enough, he added crystal chandeliers as far as the eye could see.
Since these renovations were so extensive, was Chuggies able to stay open for business while the renovations were being complete?
Oh, no, we had to close. I mean, as a customer, I wouldn't want to be around while there's boxes and paintbrushes all over the floor. Yeah, we were closed.
Were you still being paid while the bar was closed for renovations?
Yeah, even though it was closed up, the staff was still receiving full paychecks, which was really nice.
So when did Chuggies reopen from these renovations?
Well, after we were closed for all of December, we reopened in the first week of January.
How was business at Chuggies when you reopened from the renovations?
It wasn't great. Business eventually got so bad that I had to take a pay cut along with all of the other staff. Those poor minks died for some chronically empty bar stools.
Did business improve?
Oh, I wouldn't know. I got fired.
Why were you fired?
Well, as we all know, at the end of March 2020, the governor shut down all of the bars and the restaurants indefinitely, going from closed for renovations to bad business to closed for COVID. It's no surprise that he let most of us go the day after the news broke.
Since you were no longer working for the defendant, was that the last time you saw him?
No, I saw Dakota once in a parking lot in town, and that would have been about mid-July.
I'd like to talk about the time you saw the defendant in mid-July. Did you talk to him that day?
No, I walked over to him, but I realized that he was on the phone and I didn't want to interrupt.
Could you hear what the defendant was saying?
Yeah, he was talking about how he wasn't sure how he was going to cover the loan because Chuggies wasn't making enough money. And then he said that he was worried that the insurance payout wasn't going to be big enough to cover the loan.
Did you ever say anything to the defendant about what you overheard that day?
No, eventually Dakota looked up and saw me and his eyes got huge and he just frantically rolled up the window and turned away from me.
Did you ever see the defendant again after that experience in mid-July?
Yeah, I saw Dakota a few weeks later on the night of July 31st, the night of the fire.
I'd like to talk about the night of the fire. Where did you see the defendant that night?
I first saw him walk out from behind Chuggies around midnight.
Now, Ms. Young, do you recognize the defendant in court today?
Yes.
Could you identify the defendant by an article of clothing?
Yes, he is wearing the navy blue suit.
Let the record reflect that the witness has identified the defendant in court today as the person that she saw outside of Chuggies on the night of July 31st around midnight. Moving back to the night of the fire, did the defendant do anything when he came outside of Chuggies?
Yeah, he was walking away from Chuggies and like every 5 or 6 steps he would turn and he would look over his shoulder And the whole time he was really jumpy and walking super fast.
Did anything stand out to you about the defendant that night?
Yeah, there was this nasty chemical smell coming off of him. I mean, like my eyes were watering, it was burning my nose. I could practically taste it. It was terrible.
Do you know what that smell was?
Not exactly, but it reminded me of the horrible smell of Chuggies during all of the renovations, especially while Chuggies was being repainted.
Miss DeYoung, did you see where the defendant went after leaving Chuggies that night?
Yeah, that night I continued walking in the same direction as Dakota for about 12 minutes. We walked through the park like I usually do to get home, and eventually got to the fire station.
What happened when you got to the fire station?
Dakota went inside, and as soon as he did, the chemical smell went right with him.
Thank you, Miss DeYoung. Your Honor, I have no further questions at this time.
Thanks. Defense counsel?
Yes, Your Honor. May I proceed with cross-examination? Ms. DeYoung, let's talk about your time at Chuggies. You worked there for about 1.5 years, right?
Yes.
And Dakota Sutcliffe bought the bar in 2019, correct?
Yeah, he did.
And in your view, everything was going great before Sutcliffe came along, right?
Yeah, I really liked the old Chuggies. I wasn't super fond of all the changes.
Right, because before all of the changes, you would always sneak your underage friends into the bar.
Oh, the old owner wasn't as strict about checking IDs, and so some of my underage friends could come in and see the bands.
Right, and you would give out free beer and free food, correct?
Yeah, to some of our pretty regular customers.
Now, after Mr. Sutcliffe bought the bar, you spent countless nights scrubbing tables, correct?
Oh yeah.
Your tips went down
Yeah, they did.
and your hours went up.
Yeah.
So you would say that you didn't like Mr. Sutcliffe as the owner of Chuggies.
I didn't really like what he was doing with the bar. I really liked the kind of divey bar feel that it used to have.
In your opinion, Ms. DeYoung, Mr. Sutcliffe wasn't a great boss.
Yeah, I guess.
Now, moving on, Chuggies closed for renovation for the month of December, correct?
Yes.
You didn't like these renovations.
Yeah, like I said, I like the old Chuggies.
In fact, you lost out on a month of tips due to these renovations, correct?
Yep.
Now, the bar reopened in January, correct?
It did.
But you were fired in March of 2020, isn't that right?
Yeah, I was.
This firing, you felt really betrayed and disrespected, correct?
Objection compound, Your Honor.
Granted.
Ms. DeYoung, you felt betrayed by being fired in March of 2020, correct?
Well, yeah, so at first it was kind of rough, it kind of stung a little bit, but clearly Dakota had the right idea. I mean, we're still on Zoom, so I get it.
You also felt disrespected, correct?
Yeah, in the moment.
You were upset that Mr. Sutcliffe had kept other employees on, right?
Yeah, at the time.
Now, Ms. DeYoung, you mentioned on direct a phone call you overheard in mid-July, right?
Yes.
But you don't know who Mr. Sutcliffe was talking to, correct?
Yeah, I don't know.
You also don't know what loan he was talking about, right?
No, I have no idea.
Ms. DeYoung, I'd like to discuss the night of July 31st. You were out for a late night stroll, correct?
Yep.
You saw someone else walking on the street.
Yeah.
This person, they were wearing dark clothing, correct?
Yeah, he was.
Specifically a hoodie?
Yes.
and this hood was pulled up, correct?
Yes,
Now, you were about 50 feet away from this person, correct?
50 feet. Well, okay, so I was standing across the street when I saw Dakota come out of Chuggy's, so 50 feet sounds right, yeah.
Right, and it was dark outside, correct?
Yeah.
And there were no street lamps.
Right.
Thank you, Your Honor. I have no further questions at this time.
Any redirect?
No redirect, Your Honor.
Okay, you may call your next witness.
At this time, Your Honor, the prosecution calls Tobin Johnson to the stand.
Okay,
Good morning, Mr. Johnson.
Good morning.
Can you introduce yourself to the court?
Yeah, good morning once again. My name is Tobin Johnson.
How are you involved in today's case?
Well, I was a bartender at Chuggy's for a few years, starting back in, would have been 2017. And then I worked there until it wasn't there.
What was business like at Chuggy's?
Well, it was pretty good for a while. I mean, we had regulars every day. We were a big draw with the college kids, made a strong vodka Red Bull. So business was pretty solid until the pandemic hit, obviously.
Well, what was business like during the pandemic?
Right. Yeah. Not gonna lie, it was pretty bad. I mean, we were open for takeout, but Dakota still had to fire most of the staff. So it was just me and the chef that stayed.
How did that affect your job?
Yeah. Once again, not great. I mean, I wasn't that surprised. The bar just wasn't making a whole lot of money anymore. So the chef and I were actually working without pay for a little while.
Did Chuggy's ever have to shut down during the pandemic?
Yeah, we shut down in March and then we tried to reopen again in May. Got some of the regulars back. You know, everyone was making the stupid, let me get a Corona joke. So that got old, obviously. And then on July 15th, we actually got our first case in-house of COVID, not of beer. Sorry.
What happened on July 15th?
Yeah, well, the chef FaceTimes me and then he says, "Hey, dude, I've got Corona." And I thought he was joking.
Objection, Your Honor, hearsay.
okay. Any response?
Your Honor, this is not hearsay because it actually goes to the subsequent action, which would be Chuggy's having to close down based off of the statement that the former customer had said to this witness.
No, I think that was hearsay. Strike the last answer.
Mr. Johnson, why did Chuggy's bar have to close down?
Yeah, well, our chef got the coronavirus, so we had to shut down for 2 weeks. And even though I offered to be chef, we didn't want to put the food poisoning on top of the pandemic virus, so we just shut down.
How long did you all have to shut down?
Yeah, that would have been 2 weeks.
Did you see the defendant at all during that 2-week shutdown?
Yeah, of course. I'd still come in and help out however I could. And there were even a few times that Dakota asked for some of my help with the financial stuff for some reason.
Do you know why the defendant needed your help with that?
Well, he asked me to look over his loan agreement and some emails to see if he could get another extension for the payments because he was running out of time.
What do you mean when you say he was running out of time?
Well, he couldn't keep up with the payments that were on his loan agreement. So I guess that the bar could have been at risk.
Did you find anything that could help out?
No, I didn't. The only other thing I saw was this insurance policy that I asked him about.
Would you recognize a copy of that insurance policy if I showed it to you today?
Yeah, absolutely.
I am now screen sharing what has been marked as Exhibit 7B. What am I showing you?
This is that fire insurance policy I was just talking about.
Is it a fair and accurate copy?
Yeah, it's looking like it.
Has it been changed or altered in any way?
Not that I can tell.
At this time, Your Honor, the prosecution moves to admit Exhibit 7B into evidence.
Objection, Your Honor. Objection, Your Honor, hearsay.
May I respond?
Yes.
Your Honor, this falls under an exception to hearsay, specifically Rule 8036. This fire insurance policy is a record of a regularly conducted business activity, and it meets all the prongs of 8036 as listed. It was made at or near the time by someone with knowledge. It was kept in the regular course of business, and 7A is a self-authentication for 7B.
Your Honor, may I be heard?
Sure.
Mr. Johnson does not work at 5 Points Insurance. He did not make this document. He cannot attest to the authenticity of this record. Therefore, it fails to meet the 8036 hearsay exception of business record.
If we can just take a step back, could either counsel explain the legal import of pre-agreeing to an exhibit? You both counsel agreed, correct, before trial that this was an exhibit?
Yes, Your Honor.
And what were you then agreeing to, if not its authenticity?
I agree that the exhibit can be authentic, but Mr. Johnson does not have the knowledge to state that this is accurate. Since business record of exception under 8036 states that the record was made at or near the time with someone with knowledge, and Mr. Johnson did not make this record. So it fails under 8036A prong. It fails under 8036B, that is kept in the regular course of business. Mr. Johnson does not work at the 5 Points Insurance. So while this exhibit may be able to be entered into evidence under another witness or another way, Mr. Johnson is not the person that has the knowledge to talk about this exhibit.
A state?
Yes, Your Honor. Specifically, prong D of 8036 says that it can be shown by a qualified witness or a self-authenticating document. Now, 7A is that self-authentication, and you see that Sam Marcus, the director of the Records Division, authenticates this document via Exhibit 7A. So because it has this self-authentication, it does not have to be entered on the person who works with the fire insurance policy, or it does not have to be entered on the person who made this document, because 7A is that self-authentication.
Quickly, defense.
Your Honor, even though it does satisfy prong 8036D, I'm not arguing there, it still fails to meet the other 3 prongs that would be necessary, A through C, because it was not made. Mr. Johnson cannot testify that this was made with knowledge at the time or near the time it was made, that it was made in a regular course of conduct of business, because they do not work at this establishment. And furthermore, under 8036C, it talks about making the record under a regular practice of this company. And Mr. Johnson would have no knowledge of the regular practice of this company. He does not work there.
Okay, I think it's a very close case, but I'm going to grant the hearsay objection.
Mr. Johnson, did you ever ask the defendant about that fire insurance policy that you saw that day?
Yes, I did.
Well, what did he say?
Well, it was pretty weird. I'm not gonna lie. I pointed it out, and then he gave me this awkward look and said, "That's my backup plan."
Do you know what he meant when he said backup plan?
No, I was actually really confused at first. Because I didn't know what he meant, I just smiled and I nodded. And then after a few seconds, he did thankfully explain that if a fire happened, he could just collect the insurance money, is what he meant.
Do you know how much that fire insurance policy was worth?
I do. He said that since the renovations are complete, it's worth $1.5 million.
Was that the last time that you ever saw that insurance policy?
No, I saw it again on July 31st.
Let's talk a little bit more about that day. How did your shift start?
Started normally. I showed up at noon, and then it got weird when I saw this big shipment of gallons and gallons of paint thinner.
Do you know what that paint thinner was for?
No, it was confusing because we finished all the renovations a while ago, and I thought I'd never have to smell the gross chemical smell ever again.
Now, how did business go that evening?
Well, it went back to usual for a while. I was just doing my work, but then we get a phone call from one of our customers who was in the bar earlier that day, and he said that he had COVID. So we had to shut down for another 2 weeks.
How did the defendant respond to this?
Well, when I told him, it got a little tense, and he started shouting a little bit, and he said, "No, we can't close up early tonight."
Well, did you all have to close early?
Yeah, we had to. He just kicked everyone out. It was the regulars, the employees, me, everyone. And then right as I was heading for the door, was when I saw the insurance policy.
Where did you see it?
It was just on the bar.
Did it look the same as it looked when you had last saw it?
Pretty much, yeah. There's just one part circled.
What part of it was circled?
Just a bottom left.
What's on the bottom left, Mr. Johnson?
The part about arson.
Objection, Your Honor, hearsay.
Dave?
Your Honor, there has been no statement elicited onto the record by this witness at this time.
No, I think the objection went to what was on the policy. Is that correct?
Correct. I was objecting to this, Mr. Johnson stating that there was a circling of the word arson on this policy form. I submit that that is hearsay.
State?
May I have a moment, Your Honor?
Sure.
Your Honor, I bring up the exact same exception to hearsay, Rule 803-6. The fire insurance policy itself lays out the foundation for prongs A, B, and C. First, with prong A, we know that it was made at another time because the fire insurance policy has the date in question of June 2020 of last year. In addition to that, Your Honor, we know that it was made by someone with knowledge because of the self-identification. And this specific witness does not have to have the foundation to be able to testify to that.
Okay. I think what you're asking me to do is to reconsider the ruling because you're relying upon the same exception, which I did not accept. So I'm going to grant the objection.
Just to clarify, I'll re-ask, did the fire insurance policy look the same?
No, it didn't.
And did you see the defendant again that night?
I saw him, but I decided not to talk to him. It was still a little tense from the yelling. And then as I left, I heard him say, "My dream has gone up in smoke."
Mr. Johnson, do you know anything about the fire that happened that night?
I know that a fireman died, Jalen Williams. Since Dakota was a firefighter too, sometimes his firefighting buddies would come in and have some drinks, and Jalen would, and he was a really nice guy. So it's all just really unfortunate.
At this time, Your Honor, the prosecution will read onto the record statements from the previous trial made by Ali Rodrigo. He was an investigator at the scene of the fire. I will be reading the questions and my co-counsel, Ms. Conklin, will be reading the answers.
Okay, I just want to know what basis you have for reading something into the record now. Does it pertain to the witness?
Yes, Your Honor, it gives context and foundation to the fire that he just talked about in his last answer.
I'm a bit confused. Are you still, is this still direct testimony of the witness?
Not necessarily direct testimony from this witness, Your Honor, but we may read onto the record the trial transcripts, and we would like to do it prior to ending the direct examination of this witness.
For what purpose?
To provide context to the fire itself and further to provide context to Jalen Williams.
I'm sorry, but it sounds like you're testifying at that point.
Your Honor, it is stipulated that we may read onto the record transcripts from Dakota Sutcliffe's previous trial. May I screen share that with you?
Sure.
Give me just one moment. So here in stipulation 14, it stipulates that exhibit 29, which is the trial transcripts that I will be reading, is from Ali Rodrigo, who qualifies as an unavailable witness. And per motions in limine, we may read onto the record portions from unavailable witnesses in this case.
Gotcha. So it's because he's an unavailable witness that you're reading it, correct?
Yes, Your Honor.
Okay, thank you. Go ahead. Are you excusing the current witness or not?
Not at this time, Your Honor, as he still will have to be cross-examined.
Objection, Your Honor. Counsel is testifying. I understand that co-counsel has brought up the stipulations about being able to read Ali Rodrigo's records to the courtroom today, and that's perfectly fine. I submit that doing it under the witness of Tobin Johnson in the middle of their direct examination falls under counsel as testifying, and furthermore, it can greatly confuse members of the jury.
I agree. Why don't we just complete the cross-examination and any redirect that you have, and then if you want to read into the record that testimony, that's fine.
Yes, Your Honor.
Okay, good.
So
I'm sorry, go ahead.
I have no further questions for this witness at this time.
Okay, let's do crossing.
Yes, Your Honor. Good afternoon, Mr. Johnson.
Good morning.
You have worked at Chuggy since 2017, correct?
Yes, sometime.
And 2 years later, in 2019, that's when Dakota Sutcliffe took over, right?
Right, yeah. It used to be Jordan James, but two battling ideologies in a sense.
Right. Dakota Sutcliffe, this ideology of Dakota Sutcliffe, you would say that Dakota Sutcliffe is one of the most upstanding citizens of Midlands, right?
Yeah, I mean, I don't know everyone in Midlands, but Dakota's pretty good.
And Mr. Sutcliffe had the staff scrub the bar spotless every night, correct?
Objection
Yeah.
to relevance as to this witness having to scrub the bar spotless every night.
Defense counsel.
Your Honor, I submit that this goes to the witness's bias, potential bias against Dakota Sutcliffe, and that bias is always relevant.
All right, you can proceed.
Thank you. And Mr. Johnson, Mr. Sutcliffe had the staff scrub the kitchen spotless every night, correct?
Yeah, which was pretty nice. We didn't used to clean a whole lot, so I really appreciated the new direction.
Right. And no underage drinkers were also allowed at Chuggy's, correct?
No.
Now, let's talk about a Halloween event in Chuggy's of October 2019. At this event, it was at max capacity, and Dakota Sutcliffe did not allow it to exceed max capacity, correct?
That's right.
Again, Your Honor, as to Dakota Sutcliffe not allowing people into the bar on some odd day in October. That is not relevant to any fact in today's case.
Is there any testimony about that yet?
Your Honor, this is foundation. May I proffer?
Yeah, I'm just asking if there's any testimony about what was implicit in your question.
It was about a Halloween event at Chuggy's in October of 2019 that Tobin Johnson worked at. And at this event, there was a long line outside of Chuggy's, and Mr. Sutcliffe abided by the fire code, which was not allowing more people inside. It goes to filling out the character reform that we did at the beginning of this trial.
Right, I hear your testimony, but shouldn't the witness be giving that testimony?
I thought I could proffer on it based on the objection that I'm just laying the foundation for Mr. Johnson.
All right, why don't we proceed and see what happens?
Thank you. At this event, the Halloween party, the bar was at max capacity, correct?
Yeah, it was.
And Mr. Sutcliffe did not allow it to exceed max capacity, correct?
Yeah, we gave one of our regulars, Maddox, the clicker, and we just let him go.
But when Sutcliffe didn't allow for more people to exceed max capacity, he was following by the fire code, correct?
I think so. Yeah. He knows it better than I do.
Right. You went into work on August 1st, the day after Chuggy's burned down, correct?
Yes, I was going to.
And when you went there, you saw Sutcliffe crying, correct?
Yeah.
You saw them wiping tears from his face, correct?
Yeah.
You believe that there is no way that Dakota Sutcliffe would have set this fire. Isn't that true?
Objection, Your Honor, pursuant to Rule 701, if I may be heard.
Yes.
Any opinion given by a lay testimony has to be relevant to helping to determine the fact at issue or relevant to helping the jury understand the facts at trial. Now, this opinion given by this lay witness does not go towards helping the jury determine any fact at issue here, just straight up asking whether or not this witness believes if the defendant may have been guilty of that crime.
I think that objection is well placed. You shouldn't be asking this lay witness about his opinions.
Okay. And you would agree that Mr. Sutcliffe wouldn't do anything to hurt the Chuggy's family, right, Mr. Johnson?
Your Honor, I'd re-raise my same 701 objection, as this is essentially the same opinion given by a lay witness.
I think there's enough of a difference in the question that it's acceptable. I'll give an appropriate jury instruction.
Yes, Your Honor.
I'll re-ask the question for clarity. Mr. Johnson, is your opinion that Mr. Sutcliffe wouldn't do anything to hurt the Chuggy's family, correct?
Sure hope not.
Thank you, Your Honor. No further questions.
Okay. Any redirect?
No redirect, Your Honor. I just ask that this witness be released.
Okay. Sure. And you wanted to read the missing witness statement in the record now?
Yes, Your Honor.
Okay.
Question. Did you aid the firefighters at all while you were on duty after the fire was doused?
Answer, yes, ma'am. I helped recover the body of the firefighter who was killed during the fire.
Question. Do you know the identity of the firefighter who was killed?
Answer, yes, ma'am. It was Jalen Williams.
Question. Had you ever met Jalen Williams before?
Answer, yes, ma'am. I had met Williams at several scenes prior to the Chuggy's fire. Williams was a good guy, such a shame to lose him.
Question. Where was Mr. Williams's body found?
Answer, it was inside the building. Getting to it was fairly dangerous. Part of the roof had collapsed on top of Williams. We had to be very cautious going in because the structure was unsteady. It was a 1 step forward, 3 steps back kind of situation. While it was dangerous, everyone who went in there was willing to take the risk. No one in our line of work likes to leave anyone behind.
Question. Was there any hope of saving Mr. Williams' life at that point?
Answer, no, ma'am. Due to the fact that William's body had suffered severe burns after being trapped in the fire, it was clear that he was no longer with us by the time that we got to the remains.
That's all we'll be reading onto the record, Your Honor.
Okay, thank you. Why don't you call your next witness?
Hi, can you see and hear me okay, Your Honor?
Yes, sure.
The state calls Norcon to the stand. May I proceed with direct examination?
Yes.
Please introduce yourself to the court.
Hello, I'm Noor Khan.
How are you involved in today's case, Mr. Khan?
I'm a detective in the white collar crime division of the MCPD. I investigated any financial motivations the defendant might have had to burn down their property, Chuggy's Bar.
How long have you been a detective?
Well, I joined the police force back in 2017, but I've actually worked in accounting for 15 years before that. I got my degree in accounting from Dillard University.
And what were you investigating in this case?
I was assigned to investigate a tip we received to see whether Dakota Sutcliffe may have financially benefited from the burning of Chuggy's.
How did you begin that investigation?
I started by subpoenaing Chuggy's business records from Midland State Bank, focusing first on the primary bank account, tax records, and a loan that the defendant had taken out for the bar.
How did you go about reviewing those documents?
I use a standard method in my field called a transaction method, where you focus on the transactions the organization made, the communication they had, and make sure everything just fits together with the documents of that actual organization.
Were you able to reliably apply that method?
Of course.
Now, would you recognize a copy of that loan and some of the associated emails if I were to show them to you today?
I would.
I'm now sharing on my screen what's been pre-marked as Exhibit 6A, B, and C. Can you please describe what I'm showing to you?
Yes, 6B is the actual loan agreement that Chuggy's had on the bank. From the bank, 6C is the emails from the defendant to their loan officer. And then 6A is a certification from the bank confirming that these documents were kept in the regular course of business, that it's a regular business practice, and all the time and information is accurate.
At this time, Your Honor, the state moves to admit Exhibit 6B and C into evidence. 6A cannot be admitted as it's serving as a certificate of authenticity.
Defense counsel, any objection?
No objection, Your Honor.
Granted.
Can you please describe this policy?
Yes, this is a $1 million loan with a 4.5% interest that the defendant took out with Midland State Bank to renovate Chuggy's Bar. It was supposed to be paid back in monthly installments on the 15th of every month.
You said that it's supposed to be paid back in monthly installments. Is that what happened?
Unfortunately not. I uncovered that the defendant fell behind on their loan significantly at the start of the pandemic in 2020.
How did you learn that?
Well, I learned that through emails. These investigations are littered with numbers everywhere, especially on the financial end of things. But the easiest thing you can do is look at the words that the person you're investigating is saying. Thankfully, we have a bunch of emails from the defendant to read that cover all the information pretty much from the beginning.
Did you focus on these emails in your investigation?
Yes, I did. These emails can tell you the full story of how the defendant and his business was handling during the pandemic.
Before we get to those emails, when did the pandemic impact Chuggy's?
So that would have started on March 23rd of 2020 when the governor put out a stay-at-home order. All bars and restaurants had to close down, including Chuggy's. And since they were closed that month, they had no income, which the defendant was not happy about.
How do you know that?
Well, if we can look at an email they sent on April 4th, they actually...
I am now sharing my screen with the associated email that he's referring to.
Okay.
They detailed the whole issue with their loan officer, stating that they're struggling, and they specifically request a furlough program.
Did the bank grant this furlough?
No, not at first. So the defendant asked again in an email sent on May 1st. They request another furlough and they explicitly say that the bank will not see a dime if that furlough isn't granted. This time, the loan officer sent an email back granting a furlough on the principal loan, but also clarifying that interest payments would still continue to accrue on that principal.
Was the defendant able to take this time to catch up on their missing payments?
Unfortunately not. They missed their interest payment on the loan in May, and come June 1st, they emailed the officer again to ask if there was any chance they were willing to extend the furlough beyond that day.
Did the bank grant a second extension?
They did. They responded later, agreeing to extend the furlough through to July 31st, but they also make it clear that this is a final extension and that no further extensions will be given.
Was the defendant able to catch up this time on their missing payments?
Unfortunately not. They failed to make their scheduled July 15th payment, and they emailed their officer that day asking for yet another extension.
Detective, how did the bank respond when asked for another extension?
They responded the same day saying absolutely not, that the missed payments in March and April and that the interest payments from May through July were all due on August 1st.
Detective, you've talked a lot about these missing payments, but how much money was actually going to be due on August 1st?
So adding up those two delinquent payments and the 3 months of missed interest payments, that would have been $19,738.60 due to the bank on August 1st.
I'm going to stop sharing my screen now. Detective, did the defendant have that kind of money?
Not in any liquid assets. However, they did have one asset worth enough to pay it off, a commercial fire insurance policy that the defendant had on Chuggies.
Would you recognize that and some associated emails if I were to show them to you right now?
Of course,
What am I showing to you?
that would be the fire insurance taken out on Chuggies, which is 7B. 7C would be emails from the defendant to the insurance agent. And then Exhibit 7A is a certification from the insurance company confirming that these were kept in the regular course of business and that all the information contained in the documents is accurate.
Are they the same as the last time that you saw them?
Yes, they are.
The state moves to admit Exhibits 7C and B into evidence, 7A once again serving as just that certificate of authenticity.
Defense counsel, any objections?
No objection, Your Honor.
Granted.
Can you please describe this insurance policy?
Of course, it's a standard fire insurance policy. There are some additional emails, and the defendant took it out in October of 2019 to insure their bar for $1.5 million after they had finished their renovations.
Was there anything significant about these emails?
Yes, actually, we can see that the defendant emails their insurance agent asking if the bar is still insured, and she does this on July 15th at 11:09 a.m.
Is there something significant about this date, Detective?
Yes, if you pull up that last email from the loan officer again, the one confirming the August 1st deadline, you can see that it's sent on July 15th at 11:03 a.m., meaning that the defendant just so happened to confirm that their $1.5 million fire insurance policy was still valid just 6 minutes later.
Now, Detective, would this insurance policy have been enough to cover the defendant's loan?
Yes, it would have covered the entirety of the loan and left a few extra $100,000 to pocket.
And what would have happened if the defendant had been unable to make up those payments on August 1st?
If the defendant couldn't make those August 1st payments, then the bank could have taken legal action and perhaps even have taken the bar.
Thank you, Detective. I have no further questions at this time.
Cross. Well, I think I'm having a little trouble hearing you.
Oh, can you hear me, Your Honor?
Yes,
May I proceed?
sure.
Thank you. Good afternoon, Detective Khan.
Good afternoon.
For today's case, you conducted a forensic accounting investigation, correct?
That's right.
And for this type of investigation, you need an expert level knowledge regarding fraud.
That's correct.
Yet, you have not been able to earn your certified fraud examiner accreditation, correct?
Yes, for a little bit of clarity, a certified fraud examiner is a certification that's supplementary to both what I have, a financial forensics investigator certification, and then my degree in accounting.
So that's a yes to my question. You do not have this accreditation.
I do not have that one.
Now, Detective, I'd like to look into your investigation. You had access to the loan taken out on Chuggy's bar, as well as its fire insurance policy, right?
That's correct.
And this fire insurance policy, it was taken out in October of 2019.
That's true.
This was before the renovations on Chuggy's began,
Yes,
and it was 9 months before the fire.
that's correct.
And it's standard practice to take out insurance on an investment of this size, right?
Yes, in fact, it was required by the loan agreement.
Now, Your Honor, let the record reflect that I'm now going to screen share Exhibit 7B.
Okay.
Detective Khan, this is the fire insurance policy used in your investigation, right?
Yes, it's the same insurance policy.
Now, let's look at policy condition 4. This outlines the prima facie evidence of arson, right?
Yes,
And just for clarity, prima facie means impression, right?
yes,
Now, under condition 4B, the storing of flammable substances or materials within the building that are not necessary would be evidence of arson, right?
yes, and if the insurance company deems any of these prongs under section 4 to be present, then they can withhold the insurance money.
Exactly, and that's outlined in policy condition 5, right?
Exactly.
And this states, as you said, if any fraudulent means or devices are used by Mr. Sutcliffe to obtain this payout, the payout would not be awarded.
That's correct. It's to protect against fraud.
And this policy has been signed by Dakota Sutcliffe.
That's right.
Thank you. So what this insurance policy means is if there was any evidence of arson at Chuggy's, 5 Point Mutual Insurance would not have to award this payout, correct?
Yeah, should they deem that there was no arson or that there was arson.
Now, I'd like to discuss the loan payments that Mr. Sutcliffe was making. For the months of November, December, January, and February, Mr. Sutcliffe made his payments in full.
Yes, all of the payments prior to the pandemic were made in full. It was only after the pandemic hit that the defendant started to miss these payments.
Yes, the first partial payment was on March 15th.
That's correct.
And after this point, Mr. Sutcliffe was granted furlough status by his bank.
Yes, after May 1st.
And what this meant was that Mr. Sutcliffe had permission from his bank to delay the payments on his loan.
Yes, he could delay the payments up until August 1st of 2020 for both the March and the April payments, as well as the interest payments, and then August 15th for the missed payments in May, June, and July.
Yes, so all of these payments you just mentioned, their total value was equal to about $19,000.
Yes.
So to be clear, Mr. Sutcliffe's full $1 million loan wasn't due on August 1st, right?
That's right.
And Detective Khan, you were unable to conclude in your materials that Mr. Sutcliffe committed fraud.
There's no definitive evidence of it. However, there are indications of fraud.
So you were unable to conclude this, correct?
Not definitively, no.
Thank you. No further questions, Your Honor.
Redirect?
No redirect, Your Honor. May my witness step down from the stand?
Sure. And you can call your next witness.
Your Honor, at this time, we have no further witnesses, but for clarity of the jury, may I please submit to the Zoom chat exhibits 6B and C, as well as 7B and 7C that have been entered?
Sure. Any objection?
No objection, Your Honor.
Sure. Granted. Go ahead.
Then before also we close our case in chief, we would like to also tender via the Zoom chat Exhibit 1, which per stipulation 3 has been pre-admitted by both parties. This is the autopsy report of the firefighter Jalen Williams.
Okay. No objection?
No objection.
Okay. So the state rests?
The state rests our case in chief, Your Honor, and we'd ask for a brief 5 to 10 minute recess based on your discretion to prepare for the defense's case in chief.
Sure, absolutely. We'll take a 5-minute break. Both counsel present?
Yes, Your Honor, and the defense is ready to proceed.
As is the
State's
state,
ready?
Your
Okay,
Honor.
call your first witness.
The defense would like to call Dr. Mel Jelani to the stand. May I proceed?
Sure.
Good afternoon, doctor. Could you please introduce yourself to the court?
Hello, my name is Dr. Mel Jelani, and I'm a forensic psychologist.
Where do you work, Dr. Jelani?
So I work at the Overturned Convictions Group, which is a private consulting firm that I and my partner co-founded in 2014. And our firm has collectively analyzed over 100 cases and testified in about 45.
What are your responsibilities as a private consultant?
I analyze the validity of interrogation techniques, confessions, and eyewitness memory. So these are things that a lot of people think are almost infallible. They put a lot of trust in an eyewitness account, but there's really a lot of complicated brain processes that go into making memories that I think are really important for a jury to understand.
Could you explain your educational background to the court?
So I initially received my statistics undergraduate degree from the University of Florida, and I worked as a risk analyst at Midlands Insurance Company until 2001. I then received a degree in forensic psychology from the University of Arizona, and then my doctorate in clinical psychology from the University of Chicago in 2012. I'm a member of the APS, that's the Association for Psychological Science, and I'm licensed through the MPA, that's the Psychological Association of Midlands, the Midlands Psychological Association.
What materials did you use in reviewing today's case?
I reviewed the affidavits of Kieran Singh, Maddox Vaughn, and Skylar DeJong, as well as testimonies from a previous trial.
What methods did you use in reviewing these materials?
My firm and basically every forensic psychology firm uses the RAC method, RAC. So RAC method, that stands for review, analyze, conclude. So I review the materials I have access to. I analyze them through a psychological lens with my background and my professional experience, and then I make my conclusions.
How is the RIC method used in your field?
The RAC method is very straightforward, very simple, very easy to use. For that reason, it's been considered the gold standard. There's really no better way to conduct this kind of investigation. It's the standard practice in the field of psychological science.
And how did you apply the RIC method specifically to today's case?
I reviewed the affidavits of Kieran Singh, Maddox Vaughn, and Skylar DeJong. I analyzed them, and then I made my conclusions.
Now, doctor, before we begin, I'd like to establish some context to your work. Why are you here today?
I was asked by the legal team of Dakota Sutcliffe to review the case and analyze whether some of the witnesses' recollections, the way they remember things happening of events, and the identification of Sutcliffe. So when they say they saw Dakota Sutcliffe, whether those memories have some factors that stand out to me that maybe suggest that that identification might not be psychologically reliable.
How can recollections and identifications be unreliable?
Well, we all really want to trust our memories. You know, things that we remember, we always want to trust that our memories are accurate. But there's really complicated processes that go into how we take in information to our eyes and how our brain forms that into memories. And there are things called noise factors along that process that can confuse some of our memories. So maybe what we remember isn't entirely accurate.
Where do noise factors occur?
They can occur anywhere in the memory creation process, in the visual processing stage. So just the data coming into our eyes, the light bouncing off of things, or in the memory processing stage. That's where what we see actually is formed into memories.
If I could let the record reflect that I'm now screen sharing with a demonstrative.
Okay.
Now, Dr. Jelani, you mentioned these two stages. I'd like to go through them for clarity. Let's start with visual processing. What occurs during the visual processing stage?
So visual processing is how our brain processes the things we see. So it's made up of 3 steps, as you can see on this demonstrative: sensation, attention, and perception. And there are areas of possible errors in each of these steps.
Could you explain the sensation step?
Of course. Sensation is the process of just vision. The object that we see has light bounce off of it. It comes into our eyes. It's just coming in as a pattern of light that our brain later needs to use to make an idea of what we're actually looking at. But errors in this step could include things like glare or shadows. If it's dark out or you're in a dark room, if you're looking at something from an angle, and also if you don't have long enough to really look at that object or person to know what you're actually looking at.
Now let's move on to attention. What is attention?
Well, if you picture our field of view, right, we can really see a lot of information all at once, but our brain can't use all of that at once. So our brain needs to pick a small fraction of that, of our full frame of view, pick something to focus on. And errors can occur possibly if there's something distracting us from what we're really trying to focus on.
And finally, could you explain perception?
Okay, this is where it goes from just data into an actual idea of what we're looking at. So, you know, in sensation and attention, we have light coming into our eyes, but perception is our brain saying, well, I've seen objects that look like that. You know, that's not just a series of lights, you know, that's a table. I've seen tables before, and our brain kind of does that work to really help us understand what we're looking at.
Now, you also mentioned memory processing. Could you explain what happens during this stage?
All right, so we start with encoding. So encoding is short-term memory, where we have a thing that we've looked at or heard or sensed, and it's kind of stored temporarily, like a working memory. Here, a possible error that can occur is, let's say you meet someone for the first time, and they tell you their name, but you don't focus on it long enough for it to get fully encoded. So it's just lost after being put in your short-term memory, and that can happen a lot.
Next, could you explain long-term storage?
Long-term storage is where select memories are taken and processed and kind of put into our brain for longer term. It's a pretty self-explanatory name. There can be some possible errors here in long-term storage, where if we hear someone else tell us that they saw the same event, right? If we see an event and we later hear that someone else saw that same event, there's a possibility that what they tell us can be put into long-term storage with that initial memory. And when we go to access that memory later, it's been sort of changed by that new information.
And finally, could you explain retrieval?
Retrieval. This is when we recall a memory. So once something's been put in long-term storage, we can bring it back to the forefront of our mind and retell that story or just think about that story. But I think this is an important one to understand that a lot of people wouldn't really think of. That retrieval restoring process, when we create a memory, retrieve it, restore it, retrieve it, if we're maybe telling the story multiple times or just thinking about it many times, if there's little inconsistencies in that story, or even just things our brain doesn't quite remember, our brain will sometimes smooth over those details. I think that's important to remember, that recalling a memory over and over can actually change that memory.
Thank you, Doctor. Now, I'd like to discuss your reviewing of today's case. What materials did you use to review for today's case?
I reviewed the affidavits of Kiran Singh, Skylar DeJong, and Maddox Vaughn.
I'd like to focus in on your review of Skylar DeJong. What did you find in your analysis of Skylar DeJong's eyewitness identification?
So Miss DeJong claims to have seen Dakota Sutcliffe on the night of that Chuggy's Bar fire. And I think there are several potential factors that really could have affected her visual processing stage, and also the possibility that there was an alteration of memory in that recall restoring stage that suggests that that eyewitness identification of Miss Sutcliffe or Mr. Sutcliffe might not be accurate.
What factors could have affected Ms. DeJong's visual processing stage?
There are a few that Ms. DeJong notes. It was outside at night, low illumination environment, so it's difficult to see something if it's dark. DeJong also only saw that person for a short period of time and was very limited in what parts of that person's face they could see. Ms. DeJong was also a significant distance away, about 50 feet away.
You also mentioned a possible alteration of memory. Could you elaborate on this?
Yes, Ms. DeJong did not report anything to the police about seeing that person walk away from the fire station on the night of the fire. And Ms. DeJong also didn't claim to have not known about the fire until seeing an article in the newspaper, so stating that a criminal action had occurred. So an article in a newspaper is that sort of possibly, I wouldn't say corrupting, but possibly information that could possibly change a memory when you receive that new information. And after seeing that news article was when Skylar DeJong made that report.
What does this mean in the context of Ms. Singh's memory processing stage?
Ms. DeJong's memory processing stage could have been changed by intrusion errors. So new information comes in, and her brain possibly could have jumped to conclusions to kind of smooth over those gaps in her memory. For example, so there's some examples in Ms. DeJong's statement. The fact that the person walked from Chuggy's Bar to the fire station. This could have led Ms. DeJong to jump to the conclusion that the person was Sutcliffe, because Sutcliffe is a person that goes to this bar and also a person that goes to that fire station. So someone that's associated with those two locations. Another thing is possibly Ms. DeJong's opinion of Dakota Sutcliffe. So if Ms. DeJong possibly had negative associations.
Objection, Your Honor, to narrative. I would just ask that they break up this answer for clarity of the record.
Okay, objection granted. If the witness could just, respond to questions.
Dr. Jelani, how could Ms. Singh's bias have affected her memory processing stage?
Opinions that people have about someone, particularly negative ones, can you can later associate that person with the negative action. So what could have possibly happened is Mr. DeJong had negative feelings or associations with Dakota Sutcliffe and later saw, well, a criminal action might have occurred. And therefore, if a criminal action might have occurred, it's more likely, in her opinion, possibly, that the person she saw actually was Dakota Sutcliffe, while it may not have been.
Thank you. No further questions.
Okay, cross by the state.
Yes, Your Honor. May I proceed?
Sure.
Dr. Jelani, you're an expert in eyewitness testimony, right?
Yes, I am.
So you're very familiar with what a typical eyewitness identification looks like, right?
I am, yes.
There are two factors of Ms. DeYoung's identification that aren't so typical.
That's true.
First, that's Ms. DeYoung's familiarity with the defendant, right?
That's true. Ms. DeYoung's familiarity with Dakota Sutcliffe could possibly have led to one of those intrusion errors, as I stated, where she associated her with a potential negative action and caused her brain to jump to a possible conclusion.
Well, Dr. Jelani, that's not the only way that familiarity affects an identification, is it?
No, it's not.
Ms. DeYoung worked closely with the defendant for several years.
Yes.
And on the night of July 31st, she reports seeing parts of the defendant's face.
Yes, she did.
Now, you would agree that Ms. DeYoung's familiarity with the defendant means it is more likely that she's able to identify them by the parts of their face.
That's true, yes. That is a factor that suggests reliability. However, it needs to be noted that it's to some extent countered out by the possibility of an intrusion error in the memory creation process by those past associations.
Dr. Jelani, directing you back to my question though, Ms. DeYoung's familiarity with the defendant makes it more likely that she can identify them by the parts of their face.
That's correct, yes.
She also describes having recognized the defendant by the way that they walked.
Yes.
And again, that familiarity means it is more likely that she would able to be correctly identify the defendant by that walk.
That's true, yes.
So let's get to that second factor of reliability. Now, Ms. DeYoung, in most eyewitness identifications, they happen in a flash, right?
Yes.
That's not the case with Ms. DeYoung's identification, is it?
No, it's not. She had, that's a factor that definitely suggests reliability in this case. The fact that she was able to see this person for a longer period of time, although not see this person fully, which is where some of the possible errors come from.
Well, let's be clear, Dr. Jelani. She saw this person for over 10 minutes.
That's what she stated, yes.
And you would agree that the longer amount of time that a witness sees a perpetrator, the more reliable that identification would be, right?
That's true, yes.
Now, you also discussed factors of bias on direct examination, but you didn't apply those to any of the other witnesses that you reviewed in this case, did you?
I definitely took into account the prior associations that the people giving eyewitness testimonies had with Dakota Sutcliffe.
Well, let's focus on Maddox Vaughn for a minute. Now, Maddox Vaughn claims to have seen the defendant in another location around the same time, right?
She does, yes.
But in this case, you listed no factors of reliability in Maddox Vaughn's identification, did you?
Not in my report, no.
In Maddox Vaughn's identification, you know that bias had a significant factor, right?
It possibly could have. Yes, it's possible.
Well, to be clear, the defendant once previously testified for Maddox Vaughn in court, isn't that right?
That's what I saw from my materials, yes.
Maddox Vaughn credits the defendant as someone who is responsible for keeping them out of prison.
That's correct.
And this bias significantly impacts the reliability of that eyewitness identification, doesn't it?
It possibly impacts the likelihood of Mrs. Vaughn's brain to jump to a conclusion based on it, but my specific experience in psychological sciences, I'd never focus on bias when it comes to unreliability or untruthfulness of any person giving an eyewitness account. I focus on the brain processes that go to memory creation.
Dr. Jelani, you spoke extensively on direct examination about how Skylar DeYoung is considered less reliable because of her bias, right?
Bias in a sense of intrusion errors in memory creation. I claim no expertise in the reliability of someone as to their truthfulness or untruthfulness, just specifically to how that bias might have affected memory creation processes.
Then specifically for Maddox Vaughn's identification, bias is a significant factor when considering that reliability, isn't it?
It certainly is a factor, yes.
Thank you. I have no further questions for this witness.
Any redirect?
No redirect, Your Honor. I just asked that my witness be allowed to step down.
Sure. Call your next witness in.
Your Honor, the defense would, sorry. Your Honor, the defense would like to call Maddox Vaughn.
Okay, there's still some feedback, but
I think it should be fixed now. There was just, does everything sound good, Your Honor?
no, there's still a fairly pronounced echo.
Okay, I'll unmute and mute. Okay, is this a little better now?
A little bit better, yeah.
Okay, cool. Thank you. Please introduce yourself to the court.
Hello, I'm Maddox Vaughn.
What is your occupation?
I'm the head security officer over at the J Woods building.
And when do you usually work at the J Woods building?
I work usually between midnight and 8 a.m. So I'm kind of like the leader of the night shift. You know, when Midlands is asleep, I'm usually the one that's still up.
What would being the leader of the night shift entail?
You know, maintaining a security presence, monitoring all the cameras, basically making sure the area is safe and secure.
What do you normally do outside of work?
I used to spend a lot of my free time over at Chuggy's Bar.
And what was your relationship like at Chuggy's?
It was a really great place, and everyone there really supported me. At least for me personally, it was a place where friends become family, you know?
How did you feel when Chuggy's underwent the renovations that occurred?
Well, look, Dakota is a really hard worker, so I knew that whatever he had planned, it was gonna go great.
And according to your personal observations, what made Dakota Sutcliffe a hard worker?
Well, every day he went over these daily procedures, basically to make sure everything was running
Objection,
smoothly.
Your Honor, improper character evidence, if I may be heard.
Yeah, go ahead.
Opposing counsel is trying to elicit the character trait of hardworking in Dakota Sutcliffe by going on now 2 questions about her hard work and dedication to the bar.
Defense counsel.
Your Honor, at the beginning of this trial, we submitted a character form, and that submits that allows the defense to allow good character about Dakota Sutcliffe. Furthermore, all the statements being made about Dakota Sutcliffe's hardworking are referring to the personal observations made by Maddox Vaughn, being a customer at this establishment.
Your Honor, if I may
Yeah.
respond to that.
Sure.
The character traits that opposing counsel is allowed to elicit are law-abiding, community caretaker, and nonviolent. Being hardworking and putting time into a bar does not go to law-abiding, community caretaker, or nonviolent. Therefore, it is improper character evidence.
I'm going to grant the objection.
Motion to strike, Your Honor.
Granted.
Yes, Your Honor.
In March of 2020, COVID-19 shut down restaurants, including Chuggy's. What did you do?
Luckily, I still got to hang around Chuggy's, but you know, it was tough going through the pandemic.
Where were you on July 31st of 2020?
I was at the bar during the day in the afternoon, and then I got kicked out around 9 p.m. But because they had to start filling in takeout orders, so it was my time to go.
And what did the bar smell like at that time you were at Chuggy's that day?
It smelled like a regular bar. I think all this talk about it smelling like paint thinner, you know, paint thinner has a very strong smell. and it smelled like regular bar to me that day.
So what did you do after leaving the bar that night?
I decided to drive to Midlands Marina with my lovable little rescue dog, Bentley. Bentley loves walks along the water, so it was just perfect for us.
And what if anything happened when you arrived at the marina?
Yeah, I saw Sutcliffe there.
And what time did you see him?
I saw him at 11:34 p.m. sharp.
And what time did Chuggies burn down that night?
I believe around midnight.
Objection, Your Honor, to lack of personal knowledge.
Defense counsel, any reaction?
Your Honor, Maddox Vaughn, it has been established that Maddox Vaughn regularly attends Chuggies and is staying up to date with Chuggies and Dakota Sutcliffe, and would have the general basis of what time the bar burned down. Furthermore, the trial today has stated various times that the bar they burned that when it was burned down, and Maddox Vaughn would definitely have the knowledge to state this.
I'm going to grant the objection, but allow counsel to develop a foundation for that question.
Yes, Your Honor.
Maddox Vaughn, when did you find out that Chuggies burned down?
I found out pretty much the day after.
And the next day when you found out, what time did you hear that the bar burned down?
At midnight, around midnight.
And what time did you see Dakota Sutcliffe again at the marina?
At 11:34 p.m.
Okay, so you saw Dakota Sutcliffe at 11:34 p.m. and the bar burned down at midnight. How far away is the marina from Chuggies?
It's about an hour's drive away.
Thank you, Your Honor. No further questions.
Okay, Cross.
Yes, Your Honor. Ms. Vaughn, the defendant is a good friend of yours.
Yeah,
You would say that you have connected with the defendant in a way that you have not connected with most people.
I spent a lot of time over at Chuggies, so I really got to know Sutcliffe a lot. Yeah.
You would even say that you owe the defendant a lot. Isn't that right?
Yeah, I'd say so.
And you owe the defendant because the defendant once testified on your behalf in trial, correct?
I'd say I owe Dakota a lot for just being there for me. That's definitely an instance where that happened. Absolutely, yeah.
And in that instance, the defendant testified on trial to your good character, correct?
Like I said, Dakota knew me better than most people, so he really knew my true character.
But Ms. Vaughn, is that a yes to my question, that the defendant testified to your good character in trial?
Yeah.
And you personally believe that you got off of jail time because of the defendant's testimony. Isn't that correct?
I think because Dakota, like I said, showed my true character, it came across and it definitely helped. Yeah.
So for the clarity of the record, you believe you got off jail time because of the words the defendant spoke about you in trial?
It definitely lessened the possibility of me getting a longer sentence, definitely.
Ms. Vaughn, on direct, you talked about the night of July 31st. So I'd like to talk about that night with you.
Sure.
You mentioned that you were at Chuggies on July 31st.
Yeah.
That you got to Chuggies around 7:45 p.m.
Yeah, I think so.
And while you were at Chuggies, you drank, is that correct?
Yeah, 1 or 2 beers, something like that.
In addition to those couple of beers you mentioned, you also had a vodka Red Bull, correct?
Yeah, probably.
Then you mentioned at 9 p.m. the defendant kicked you out of Chuggies, correct?
Well, kicked out. They had to start filling in takeout orders, so it was just time to go for me.
And you did leave at 9 p.m.?
Sometime around 9, yeah.
And when you left at 9 p.m., the defendant actually kicked everyone out of the bar. Isn't that correct?
Yeah, I guess so. I mean, they had work to do. Makes sense.
But Ms. Vaughn, specifically, the defendant kicked everyone, including the employees, out of the bar that night, correct?
Yeah, I think so.
So when you left Chuggy's on July 31st, the defendant was the last person at Chuggy's.
I'm not sure.
Objection, Your Honor, speculation.
Your Honor, this is cross-examined. The witness is able to say they don't know if they don't know.
Yeah, can you explain your objection? I'm sorry.
Opposing counsel is asking whether or not Dakota Sutcliffe was the last person in the bar on July 31st, but Ms. Maddox Vaughn would be only in the seating area part of the restaurant and would be unable to testify if there was anyone in the back in the kitchen working behind the general seating area, and asking a question about the amount of people left in the bar would be speculative.
Your Honor, may I respond to that briefly?
Sure.
My question prior to this question was asking that the defendant kicked everyone, including the employees, out of the bar. The witness said yes. Therefore, it is the witness's rationally based perception, and she has already testified that everyone left that night. I'm clarifying for the record that the defendant was still there.
Okay, I'll allow it. Go ahead.
Yes, Your Honor. Ms. Vaughn, for the clarity of the record, when you left Chuggy's that night, the defendant was the last one there.
Yeah.
And after leaving Chuggy's, you then stopped at home, correct?
Yep.
At home, you had 2 more vodka Red Bulls.
Sounds about right.
And you also had a shot of whiskey.
Yeah.
After drinking at home, you then went to the marina, correct?
Yeah.
And
that sounds right.
You often go for walks down at the marina with your dog, right?
Yeah.
But you don't normally see people on this walk.
People I mean, I see a lot of people I recognize, I'm there pretty often. But I specifically saw Dakota there, which I didn't see before, no.
So Ms. Vaughn, for the clarity of the record, when you go for your walks around 11:30, you do not normally see people, correct?
I'm not sure what you mean about normally seeing people. There are people there all the time.
There are people at the marina at 11:30 p.m.
No, but earlier, later around then. I specifically saw Dakota there at that time, which was not something I noticed before.
Yes, Ms. Vaughn. But on the night of July 31st, you claim to have seen this person that you claim to be the defendant.
Yes.
To be clear, this person was 70 feet away from you.
Something around there. Yeah.
And you shouted out to this person.
Yeah, I shouted hi, but Dakota didn't hear me.
So this person was so far away that they could not hear you shouting, saying hello?
Guess not.
And to be clear, you believe you saw one of your closest friends at the marina, but you never went and said hello?
I was pretty far away, like you said. I was just on my walk. I didn't know if they were doing something, so yeah.
So you never went and said hello?
No, did not.
Now, Ms. Vaughn, I'd like to talk to you about your knowledge of Chuggy's. You mentioned that you're a frequent visitor of Chuggy's, correct?
That's right.
So you were aware of the defendant's renovations to Chuggy's, correct?
Yeah.
And in the midst of those renovations, the defendants once told you that it would be easier to torch the place and start over, correct?
I mean, yeah. Dakota was going through a lot with the renovations, trying to keep up with everything. So I'm sure I've heard a lot of variations of that.
But to be clear, Ms. Vaughn, you once heard the defendant say it would be easier to torch the place and start over, correct?
Correct, yeah.
Thank you, Ms. Vaughn. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor.
You can call your next witness.
Yes, Your Honor. The defense would now like to call Ms. Alex Silva to the stand.
Okay.
May I proceed?
Yes.
Please state your name for the court.
My name is Alex Silva.
Where do you reside, Ms. Silva?
I've lived in Midlands for most of my life.
What is your current occupation?
I currently work for the Midlands Department of Parks and Recreation, or DPR.
And how are you related to this case today?
I was working the night of the fire at Chuggy's.
What experience do you have firefighting, Ms. Silva?
Well, before I worked for the DPR, I was a volunteer firefighter at the Midland Center Fire and Rescue Department for around 8 years.
What has your experience firefighting been like?
Oh, wow. Firefighting is just so wonderfully rewarding. And I get to work with a great group of people who care for each other. As a volunteer, I don't get paid to run into burning buildings. I do it to help people.
And Ms. Silva, did you have a relationship with Jalen Williams?
Yeah, I've known Jalen my entire life. We grew up together. We did training together. We were partners for firefighting.
And did you have a relationship with Mr. Sutcliffe?
Yeah, I first met Dakota around 2016. He'd also been a volunteer firefighter like me. We worked many shifts together. I'd even say that we're friends, but we don't really spend too much time outside of firefighting.
And based on your personal experience, what has it been like to work with Mr. Sutcliffe?
Dakota is a great firefighter. He shows up for his shifts on time. He works hard. He even takes on extra shifts and cares for everyone. I've seen him go so above and beyond. We're like his family.
Now, Ms. Silva, you were working the night of the fire. How did that night begin?
It was around midnight as usual, and then I remember the call coming in, and everyone just jumped into their gear and got into the truck.
Was Miss Sutcliffe on duty that night?
Yeah, Dakota came in through the back door. He got into his gear and into the truck.
Did you know where the fire was?
No, I didn't find out until I asked the driver of the truck, and he told me it was Chucky's.
Ms. Silva, how would you go about explaining that night?
Well, in order to understand what happened, you need to understand the 2 in, 2 out system. It's something very important we learned during training.
Let the record reflect that I will now be sharing Exhibit 9, which has already been pre-admitted into evidence under Stipulation 13. Okay. Ms. Silva, do you recognize this document?
Yes, I do. It's the firefighter trainee manual specifically for the 2 in, 2 out system.
Could you please read number 2 of the operational guidelines?
Clear, brief, and concise communication is to be used at all times.
Now, could you please read number 4?
At all times, when entering a compromised structure, 2 firefighters must enter the building together. These are called the 2 in firefighters. While the 2 in are inside the building, there must be 2 additional firefighters outside that are monitoring for the conditions and safety for the 2 in. This outside pair of firefighters are called the 2 out.
And finally, could you please read number 6?
Inside the fire, the 2 in must remain within sight lines of each other at all times and also may not be more than 40 feet from one another.
Thank you, Ms. Silva. Now, let's get back to the night at Chuggy's. What happened once you arrived on the scene?
We all saw smoke coming in through the back door, and our incident commander told us that we had to use the 2 in, 2 out system, and Jalen and I were the 2 in, Dakota and Kelly were the 2 out.
What happened once you and your partner approached the structure?
Jalen broke down the door and I punched a hole through the wall so that we could create ventilation.
Did you enter the structure?
When we did, we saw that it was an inferno. The fire was just concentrated to the upper right of the kitchen and the bar, and we knew we had to check for people. That's what we were there for. So we checked there, and then we went down to the basement. We checked the office and the storage. There was no one there.
So what was your next step, Ms. Silva?
After we came up, that's when I realized that we didn't check the bathrooms down the hallway.
And how did you go about executing this check?
I looked at Jalen and I pointed to the right, of the hallway.
How did Mr. Williams respond to this?
He gave me a thumbs up.
And what did you do next, Miss Silva?
I turned to go down the hallway, and I really thought we were both headed in that direction.
What do you mean you thought?
I wrongfully assumed that Jalen would be following me. I let him out of my line of sight.
And Miss Silva, what happened after you let Mr. Williams out of your line of sight?
I heard this huge cracking sound, and there was this crash behind me.
How did you respond to this?
I turned around to grab Jalen so we could leave, but he wasn't there. He just wasn't there.
What do you mean he wasn't there?
Well, I saw a section of the kitchen had collapsed, and I knew then that Jalen was gone.
Miss Silva, I'm sorry for your loss. Would you like a moment?
No, it's all right.
Could you tell us what happened next?
A second later, I felt someone grab me. It was Dakota and Kelly. They had come in when they heard the structure collapse, and they came in to rescue us.
And then what happened?
Dakota asked me where Jalen was, and all I could do was point to that helmet. It was on the ground just sitting there, and Dakota knew what that meant.
So what did you guys do next?
The fire was getting worse and worse. So we raced for the door, and that's when I saw the entire bar go up in flames.
Miss Silva, how did you react to the death of Mr. Williams?
I was devastated. Losing someone like Jalen, like a firefighter, is so difficult, and we really had a good plan. The 2 in 2 out method should have worked without the loss of a life if it were executed correctly.
What do you mean if it was executed correctly?
I let Jalen out of my line of sight. I only trusted the assumption that he was following me, and I didn't think to make certain that he actually was a part of me. Like, I really feel as if I'm part to blame for his death. I could have helped. I could have saved him. It should have worked out.
Thank you, Miss Silva. Thank you, Your Honor. I have no further questions at this time.
Stated on cross.
Yes, Your Honor. May I proceed?
Yes.
Good afternoon, Ms. Silva.
Good afternoon.
You've been friends with the defendant for a few years now, right?
Yeah, I have.
You're aware that the defendant owned Chuggy's Bar,
Yes.
and you actually went to Chuggy's after the renovations took place.
Yeah, I did.
You thought the place looked amazing, right?
Yeah, they did a great job with renovations.
That's when the defendant told you that they got a $1 million loan for those renovations.
Yeah, he did.
After a while, though, he just started to complain about Chuggy's, right?
He did, but I didn't really ask him too much. It's not really any of my business.
Well, he in fact did tell you that things at the bar were getting way too expensive, right?
Yes, he did, but like I said, I didn't ask him too much about it.
That's a yes to my question, that he said the bar was way too expensive.
Yes.
And he also said that he should just torch the place down and it'd be worth more, right?
He did say that.
Now, I just want to talk a little bit more about the night of July 31st. You were at the fire station that night.
Yes, I was.
When you got there, the defendant wasn't there, was he?
No, he wasn't, but he came in later.
We'll get to that in a moment. Now, you were surprised that the defendant wasn't there because you hadn't seen him for hours, right?
Yeah.
Now, when the call about Chuggy's Bar came in, that was around midnight?
Yes, a call had just come in. We didn't know we were going to Chuggy's.
Right. And when the call came in, as you mentioned on direct, you all sprang into action.
Mm-hmm.
And then you went down to the garage.
Yeah, we had to put on our gear and get into the truck.
And as you were on your way to the truck, that's when you finally saw the defendant come into the station, right?
Yes.
When the defendant finally shows up, he reeked of the strong smell, right?
I mean, there was a smell coming. It was weird. I'll admit that.
It was coming specifically from the defendant though, right?
I would say so.
And you thought that it was a strong chemical smell.
Yeah, I didn't really, I couldn't put my finger on it, but I wasn't sure if it was like gasoline or paint thinner. I didn't know.
And when the defendant finally shows up, he said, "Midland Center, I sure hope it's not Chuggy's bar," right?
Yes, he did.
When you asked the defendant why he would say such a thing, he ignored you.
Yeah, he did. But I think he was just, we had to spring into action. It was going really quickly.
That's a yes to my question, that he ignored you when you asked him why he said, "Midland Center, I sure hope it's not Chuggy's."
Yes, he did.
Now, when you all got onto the fire truck, you did find out that the fire was indeed at Chuggy's bar.
Yes.
And as you mentioned earlier, you and Mr. Jalen Williams were the two in.
Mm-hmm.
I just want to talk about that interaction just for a bit, if that's okay.
All right.
You all were at the top of the stairs.
Yes.
And you turned to Mr. Williams and you directed to go to the right.
Yes, I did.
Now, at this moment, you did not see Mr. Williams go left.
No, he didn't.
You did not see Mr. Williams go back down the stairs.
No.
You didn't see Mr. Williams go in any other direction, did you?
No, he just gave me the thumbs up.
Now, when things got too dangerous, that's when the defendant came and pulled you out of the bar, right?
Yes, he and Kelly Juice followed protocol and they came in to rescue us as the 2 firefighters.
Now, when the defendant pulled you out of the bar, he looked at you and said, "I never meant for this to happen," right?
He did.
I have no further questions, Your Honor.
Okay, any redirect?
No redirect, Your Honor.
Okay, defense rests.
Yes, at this time, the defense rests their case in chief.
Okay, why don't we take a 5-minute break and then we'll begin with closing arguments.
Yes, Your Honor, the state is back and ready to proceed.
Terrific. Yeah. Okay, why don't we hear closing arguments?
Before I begin, motion to reserve any remaining time for rebuttal.
Sure.
Opposing counsel, members of the jury, may it please the court. He was running out of time. We've talked a lot today about the days and weeks leading up to the fire at Chuggy's on August 1st. But there's one day, the most important day, that we haven't actually talked about yet. And that's August 2nd. You see, when you go back into deliberation, you're going to have Exhibit 1 with you. You'll see right at the top of the autopsy report for Jalen Williams that on August 2nd at 10:14 a.m., they conducted an examination of him. You'll see that Jalen's head was crushed under the debris of a collapsing ceiling, that his body was so charred that they couldn't perform an internal examination. They couldn't even recognize him. Members of the jury, we are not just here today because the defendant decided to burn down their bar for an insurance payout. We are here today because the defendant decided to burn down his bar for an insurance payout, and Jalen Williams, a young man, a young firefighter, someone who went into Chuggy's to save lives, lost his own. Jalen Williams had his entire future ahead of him. And that's why we're here today. We're here because he deserves justice. He deserves to have the person who is responsible for his death take accountability. That's why, as the state, we have brought a charge of aggravated arson. This means that we needed to prove to you beyond a reasonable doubt 3 things. First, that the defendant committed an act of arson with the intent to defraud. Second, that there was a substantial risk of harm by committing this act. And third, that the defendant knew this was a possibility when he did it. Members of the jury, the harm is undeniable. Jalen Williams should be here today. And the defendant, being a volunteer firefighter, someone who is intimately familiar with just how dangerous those situations can be, knew the risks when he said it. So let's take a step back and talk about how we know what we know, how we know the defendant is responsible for this fire. Because this case doesn't actually start on August 1st. It starts back in 2019, when the defendant takes out a loan of $1 million to perform renovations to their bar. They want to make it a better place, a better business. None of this is wrong. And they close down for a few months to get the renovations complete. But when they reopen in January, business isn't exactly what they'd hoped. The regulars aren't coming in like they used to. The college kids are still away, and they're taking losses. So much so that in February, Chuggy's employees had to take a pay cut just to sustain everything. But the defendant could have never predicted what would happen in March. Because on March 23rd, Governor Walton ordered all bars and restaurants to close for COVID safety regulations. Seeing what was coming on the horizon, the defendant fired all of their staff the next day, but that wasn't enough, because with no customers at all, the defendant misses a loan payment to the bank in April, and another one in May, and another one in June. And while all of this is happening, he's doing exactly what he's supposed to. He's saying, we're struggling. We need help. We need more time. And the bank granted it again and again and again. But when the defendant missed yet another payment on July 15th, the bank finally said enough. They said that $20,000, the sum of all that missing money, is going to be due on August 1st. You have no more time. The defendant is desperate. He knows he doesn't have that kind of money unless he uses the one thing that he does have. And just 6 minutes later, he reaches out to his fire insurance agent. He checks in just to make sure that his $1.5 million policy is still active, and it is. So what do desperate people do when they're put in a desperate situation? Dakota acted. And on July 31st, Chuggy's receives a shipment of gallons and gallons of paint thinner that we know, that we both agree started the fire. And just hours later, the defendant kicks everyone out of Chuggy's. And what do they do in that time? They pour that paint thinner across the bar floors. They light that match and they walk out rich. And as they're walking out, who sees her but Skylar DeYoung? Skylar DeYoung sees the defendant as he's walking away, as he's heading to the fire station. But just before he can get there, that 911 call comes in and reports Chuggy's on fire. And it's then that the defendant arrives. So they pile into the truck. They head downtown. and they arrive on scene. Who goes in to save those lives? Jalen Williams does. And when he's in there, when he's searching for the people that might be left behind, the ceiling collapses on him and he is killed. He can't even be retrieved until the ashes have stopped smoking the next morning. Members of the jury, there can be no doubt. Dakota is not an evil person, but he was a desperate person. And desperate people still need to be held accountable when their actions, as good intentioned as maybe they might have been, hurt others. Dakota Sutcliffe was running out of time. Dakota Sutcliffe acted that way too. Find the defendant guilty of aggravated arson. Tell the defendant that he is out of time. Thank you.
Counsel. You may proceed.
Yes, Your Honor. They saw what they wanted to see. Your Honor, may it please the court, opposing counsel, members of the jury. Today, the prosecution tried to convince you that Dakota Sutcliffe committed an act of aggravated arson. But after hearing the testimony, it has become clear that this could not be further from the truth. Before Dakota Sutcliffe got his hands on it, Chuggy's was just a rundown dive bar. But he had a vision, and he decided to embark on this dream. He took out a loan, started renovations, and after hours of construction and work, built Chuggy's into what it was. He had achieved his dream. He was the proud owner of Chuggy's Bar, the pride and joy of Midland Center. And then, on the night of July 31st, tragedy struck. Mr. Sutcliffe was working at his volunteer position at the Midland Center Fire Department when a call came in. There was a fire in Midland Center, a fire at Chuggy's Bar. When they arrived at the scene, all Mr. Sutcliffe could do was watch. Watch as all his hard work, his time, his money, his dreams burned down in flames. And now he's being put on trial for a crime he did not commit. The prosecution has presented you with a flawed theory. They are asking you to stretch the truth and make false connections. They want you to see their side of the story, see what they want you to see. On the other hand, we, the defense, have presented you with the real side of the story. The fire at Chuggy's was a tragic incident, one that Dakota Sutcliffe simply cannot be found guilty of. We called 3 witnesses to the stand. First, we called Mel Jelani, an expert in forensic psychology and a private consultant. Dr. Jelani told you that the alleged eyewitness, Skylar DeJong, of today's case may have seen what she wanted to see. He informed you that Skylar DeJong suffered from a severe lack of sufficient visual information, as well as a possible alteration of memory that would make her identification of this person on the night in question unreliable. Next, we called Maddox Vaughn. As a loyal customer of Chuggy's Bar, Ms. Vaughn was able to speak to all the work, time, and love that Mr. Sutcliffe invested into Chuggy's. Furthermore, she was able to place Mr. Sutcliffe at the Midlands Marina at 11:34 p.m. This was only moments before the bar was set on fire. Members of the jury, it would be physically impossible for Mr. Sutcliffe to have been at Chuggy's when the fire was set. Lastly, we called Alex Silva to the stand. Alex Silva told you about not only how devoted Mr. Sutcliffe was to Chuggy's, but also to the Midland Center Fire Department and all the terms and regulations that accompany fire safety. In addition, Mr. Silva was a responding firefighter to the Chuggy's fire and was inside Chuggy's with Jalen Williams. Ms. Silva explained to you that after a brief miscommunication occurred between herself and Jalen left Alex's line of sight. Only moments after this breach occurred, Jalen was tragically killed. Now, as Your Honor well knows, in order to prove aggravated arson, the prosecution must prove 3 elements to you beyond a reasonable doubt. First, that Dakota Sutcliffe committed an act of arson. Second, this act was committed with the intent to defraud. And third, this act subsequently created a substantial risk of serious physical harm to anyone other than the defendant. Now, I'd like to take these elements one by one for clarity of the court. Let's start with the first element, that Dakota Sutcliffe committed an act of arson. In order to prove this, the prosecution called their alleged eyewitness, Skylar DeJong, to the stand. On the other hand, we, the defense, brought our expert, Dr. Melgelani, to evaluate the reliability of this identification. Dr. Jelani told you that Ms. DeJong saw what she wanted to see, and that there were several important flaws in this identification. First, that Ms. DeJong lacked sufficient visual information to make an identification. This person was seen from 50 feet away in the dark with only glimpses of their face being caught in the span of a few seconds. Secondly, he explained to you that an alteration of memory could have occurred. When reviewing Skylar DeJong's testimony, an important factor stood out in his review. Ms. DeJong did not initially report the sighting of this person on the night in question to the police. It was not until she had read a news article which established that the Chuggy's fire was a criminal activity that she reported this. Dr. Jelani explained this to you as an intrusion error. Skylar's memory of the events was being filtered through the news article she had been exposed to, which caused her to jump to the false conclusion that the person she saw that night was Mr. Sutcliffe. She saw what she wanted to see and falsely bridged the gaps in her memory. Second, they had to prove that there was an intent to defraud. In order to prove this, the prosecution called Detective Noor Khan to grossly oversimplify the financial issues at stake. Detective Khan presented you with 2 pieces of information. First, a completely standard fire insurance policy that was legally required under Mr. Sutcliffe's loan agreement. And second, loan payments that never actually went unpaid due to the defendant's furlough status. The prosecution is trying to force these pieces together into a puzzle that simply does not fit. The bottom line is Detective Noor Khan got up on that stand and told you that he was unable to conclude that Mr. Sutcliffe committed fraud. Lastly, they had to prove that this act subsequently created a substantial risk of serious physical harm to anyone other than the defendant. Now, in contemplating this burden, I'd like to direct the court's attention to the case law of State v. Wyman, which found that if there is any deviation from standard operating procedure by emergency personnel, the defense is presented with an opportunity to argue that the emergency personnel were not acting within the scope of their employment, and therefore would not be contemplated as the class of victim under Midland's Code 18401B. When Ms. Silva let Jalen Williams leave her line of sight, a breach in the emergency protocol occurred. And as difficult as it is for us to grapple with this, we must recognize that this breach occurred and its effects must be seen. If you have even the slightest bit of doubt that the prosecution has failed to prove to you even one of these elements beyond a reasonable doubt, then they have not reached their burden today. The prosecution is asking you to see what they want you to see. The defense is asking you to see the truth. Therefore, we ask that you find the only verdict consistent with the facts and the evidence and find the defendant not guilty of aggravated arson. Thank you.
Thank you. State, any rebuttal?
Yes, Your Honor. May I proceed?
Yes.
Opposing counsel says that we're trying to force you to see what we see. So really ask yourself, have we done that today? Have we tried to force you to see something that isn't there? Or have we shown you exactly what we all know to be true? We know that Dakota Sutcliffe was in a desperate situation. We know that Dakota Sutcliffe had $20,000 due on August 1st. We know Dakota Sutcliffe didn't have that kind of money. And we know that Dakota Sutcliffe ordered the paint thinner to Chuggy's bar. And we know that Skylar DeYoung saw Dakota Sutcliffe just minutes before the fire was reported sneaking out of Chuggy's. And we know that Jalen Williams, when he went in there, he was not acting beyond the scope of his employment. He was not a random civilian running into a burning building. He was a firefighter. He was a hero. He went in to save lives today. And the defense tried to come before you and say that because he went into the kitchen to look for those people, that it doesn't count anymore. That he no longer counts as that person, as that life-saving emergency personnel. Members of the jury, we're not asking you to be unreasonable. Far from it. We're asking you to look at everything that you heard today and make the most reasonable choice there is. To see the honest truth. To see that Dakota Sutcliffe is guilty of aggravated arson. Follow the evidence, follow your conscience, and find the defendant guilty. Thank you.
Thank you. I'm now going to ask the competitors to turn on their videos just to enable us to finish off our sheets. And after that, we'll submit our ballot and then just give a few comments to you. Does that sound good? Okay, so if everyone can turn on their video. That's both counsel and witnesses. Terrific.
I submitted my ballot.
You submitted your ballot, right? Wow, I feel stupid. I'm gonna need just a few minutes.